deeply into minute differences in language and assign inordinate importance to that language. And sometimes the language and different words are also used. Sometimes it is merely a stylistic device. And two judgments I'll just cite. One is a very old one, Crown versus Khushi.
Before you cite the judgment, I mean, on the one hand is the argument that you made. On the other hand, there is an argument which has been accepted by this court in a couple of cases that the words subject to the Constitution and subject to the law create a restriction that you can do everything unless it is prohibited by the law or the Constitution as it exists. दोनों को अगर आप हार्मोनियसली उसको देखें या उसको दोनों एंगल से देखें तो which interpretation to you is more appealing? आपने अभी पढ़ा आर्टिकल 67 again subject to the constitution, उस पे भी ये interpretation कि ये restrictive है ज़्यादा plausible लगती है compared to attributing redundancy to it.
My lord, what all I was trying to say is that if it had not said subject to the Constitution, it would nonetheless have been subject to the Constitution. Yeah. And perhaps not too much meaning need be ascribed or forced into it, and that's why I was just citing these two judgments.
Then why should too much meaning be ascribed to the and law bit of it?
My lord, because the plain meaning...
Yeah, you can't have it one way.
No, because what I'm saying is that in a particular provision, it says that it will be subject to Constitution.
In a subject Constitution, तो हर कोई समझता है, और and law जो है उसको तो आप full entry 58 I mean surely
No, well, my lord, if I can...
कुछ तो rationalize कीजिए.
I'll just deal with that, sir. If I can just point out the judgments. Crown versus Khushi Mohammed, PLD 1953, Federal Court, page 170, at 174.
Which year is it?
1953, Federal Court, 170.
What is the proposition?
At page 174. That sometimes this distinction in the words used is merely there for stylistic reasons, and there is not a clear legislative intent.
But is that your point,
things.
that this is stylistic?
The subject to
is stylistic.
Constitution.
And law. Not law.
No, because
the Constitution is stylistic, law is not stylistic.
No, because my case is that the subject to the Constitution is there all the time, whether you say it or not. Sometimes they say it, sometimes they don't.
You are saying it will have to be read in context.
Yes.
Sometimes these words, unless some case comes in and those words become critical, then they have to be read in context.
Yes, exactly.
Simply put.
Exactly. But when they have specifically added something more, which is not always understood. Sometimes, for example, constitutional rules might stand on a higher
ये जो
footing
आप argument
than
कर रहे हैं, ये आप argue stylistic है. This is in the context of wherever it is used subject to law in the Constitution, or are we now going to say 191 में stylistic है, but Article 14 में stylistic नहीं है? How do we read that then?
It was specifically in response to my Lord's question that why is this word subject to the Constitution used when it's automatically...
अब तो subject to law पर आ गए हैं ना?
जी, मैं subject to law के हवाले से मेरी गुजारिश ये है कि an addition is made, because that is not something that is automatically understood, because there can be rules with constitutional backing that do stand on a higher pedestal than statute. That is a possibility. But as far as the rules made under 191 is concerned, the addition of the words and law, when compared to other kind of constitutional rules, that is a significant difference.
I need to take a look at Article 99.
Ji, sir. The federal government's...
Yes. Kindly take a look at Clause 2 as it stands now.
The federal government shall, by rules, specify the manner in which orders and
You don't
other.
have to read the rest. Now, here again, direct rule-making power conferred by the Constitution on the executive branch.
Yes, sir.
Obviously subject to the Constitution, or not subject to law. I'm asking you.
Sorry. Yes, of
Not
course,
subject
subject to the Constitution.
So, where the executive branch is concerned, we are to say that the rule-making power is on a higher pedestal, even though under our parliamentary democracy, for example, federal government is collectively responsible to the National Assembly. In fact, the Prime Minister and so on, they arise out of Parliament itself. It's not a presidential form of government, it's a parliamentary form of government, Westminster style. So there, the executive branch is put on a higher level, that even though they arise out of and are answerable and accountable to Parliament, in their rule-making power, they can just ignore any law. And that, in fact, Supreme Court can't, although it is a separate branch of the state, Supreme Court, because law, you say, is an enabling power, and therefore the Supreme Court is not the master of its own house. The master of the roster is Parliament.
My Lord, I wouldn't say that they are master.
Is this a constitutionally viable argument?
I wouldn't say they are master of the roster, the Parliament. Because
I asked you, you specifically have said, law can repeal the Supreme Court rules.
Yes.
What more is there left?
yes, that doesn't automatically, my humble submission
That's
is.
a matter of competence here. What more is left?
My Lord,
They can say, we throw out your rules 1980, so that's like 43 years standing rules. We throw them out. Out you go. We make our own law. We are the master of the roster. And in our rule-making power, we empower the federal government to do whatever we wanted.
that, if they did that, my Lord,
आप देखिए ना, this level, at the highest level, committee, no committee, everything, they are, and I'm going to use something very strong, but I'm saying it with all deliberation. This argument reduces the Supreme Court. All due respect to Parliament, it reduces the Supreme Court to a hapless plaything for Parliament. This surely cannot be right.
Lord,
This surely cannot be a constitutional interpretation. What do you say to
my
that?
Lord, I would humbly.
Please don't say that it can be a hapless plaything of the Chief Justice. Don't say that.
Salahuddin, I think I beg to differ with my learned colleague on the Parliament being the master of the roster. It could have been, had the Parliament kept that power with themselves.
Yes.
Had the members of the Parliament been in charge of this, yes, we could have said that they've become master. They've actually left it to us. So instead of saying that the chief is the master, they're saying 6 people or 3 people or 5 people are the master. So it's not them. Had they retained it with them, then they could have.
Choice is ultimately theirs. That's the problem.
My Lord, with
There is,
respect, I look
there
at
Committee
it.
is the
Salahuddin,
creature of Parliament.
I
If
think
they
there's
can
creation
do
of
this,
Parliament.
if they can do
There's a
this, and
justification.
we say that you can do this,
There's
then
a-
they can do that also.
Tomorrow when they do
That
that,
is
we'll
the thing.
strike it
I'll
down.
address this. I'll address this.
Okay, but-
every law also has to be seen in its historical context. The master of the roster and the powers exercised probably were viewed by the representative of the people to have been exercised against their interests. So that is why there was a need for the law. And we cannot ignore or just turn a blind eye to the historical context of why it was so necessary.
And somehow
My Lord,
we
there
sort of
has to be-
referring to the Parliament in a bit of a derogatory sense. You see, as if they're the Indians or some people outside somewhere. You see, it's the Parliament, and Parliament is a house which represents the people of Pakistan. So people of Pakistan, through their representatives, cannot have a right to say how the Supreme Court has to function. It is, we are trustees doing work for the people of Pakistan. They can't turn around through Parliament, tell us how to regulate things. So even if the word dictation was used, I would say, yes, people can dictate what are we supposed to do. I mean, who are we? We're
Well,
just trustees.
The people can dictate,
it
the
is not
government
just
can't.
the voice of
And-
the
and-
people,
But the
and
parliament are the
people-
chosen
and the
representatives
people
of
have
the
already
people, sir.
spoken in
it is
terms
not,
of the
it is not
Constitution.
just,
So if the people want to speak again, obviously, people have given the Constitution. Let them say so in the Constitution.
it is not,
32 or 34 MNAs sitting in the parliament, they don't speak for the people. They speak for a party for the reason that the majority is the government actually. So it is rolled into one. The executive and the parliament are rolled into one.
speaking
If-
for my,
if-
speaking for myself,
If
let us not,
if the people of Pakistan have to have their will, yes, it is their country. They have given the constitution. They have a right and they have the power to amend it. The moment they amend it, the entire argument finishes.
My lord,
आगे
may I-
बढ़ें,
may
आगे
I-
बढ़ें।
जी, I just wanted to say to.
Are you concluding now?
Just 10 minutes. Sir.
जी।
As far as this is concerned, just to wrap up the relative primacy of statute and rules, my submission would be that no doubt that the two spheres, legislative competence and infringement of judicial independence, those are completely separate issues. So if Parliament has legislative competence to even completely repeal and modify and bring in new Supreme Court rules, it will nonetheless
Will
be...
it not be subject to anti-55?
Sorry, sir?
If they legislate a new law, the parliament, will it not be subject to anti-55?
As far as creating additional jurisdictions is concerned, yes. As far as practice and procedure is concerned, my submission has been that it doesn't depend on NT55. But what I'm saying is that if Parliament does repeal the Supreme Court rules, it brings in its new rules, your lordships will check those rules on the touchstone of Article 10A. And if there's anything in those rules that effectively impairs your lordship's independence, then your lordships would be free to strike it down. It is, for example, sir, that Parliament has competence to pass any criminal law. But if Parliament passes a law that anyone who looks at us funny will be hung, your lordships would not examine the case on the basis of legislative competence. Your lordship would strike it down as being contrary to Article 9 and so on and so forth. So those two aspects have to be segregated. Now, if to move on, sir.
So you mean that door can be open, but scanner has to be installed?
Yes, if the opening of the door is misused, then your lordship can step in. Now, as far as independence, that brings us to the independence of judiciary, sir. It is exactly, and the opening of the door, wala jo provision, as far as I understand it, it's very different from legislative competence. Let's say a law seeking to regulate a trade is challenged on the touchstone of Article 18, or a law imposing a property tax is challenged on the touchstone of Article 24. This court will not say that, oh, if we open the door, tomorrow they might take away all the property, or tomorrow they might prohibit in the guise of regulation. Your lordships will examine the substance
Yeah,
of the
rather
law.
than going into vague examples, what this law does not do, which is significant, I don't know if I've noticed it, its significance or it's not significant, is we have this whole concept of mandatory and directory provisions. Now, this law does not stipulate anywhere whether consequences of not strictly abiding by it. So maybe Parliament, in deference, did not say maybe the next step, any case so decided in contravention will be considered quorum non judice or something. They could have done that. Then it would have become a mandatory. That's my understanding. I may subject to correction. Here it still has left room whether we call it wriggle room or whether we call it interpretation of the 3 senior judges of the Supreme Court, it's not taken away everything, because there's no consequences that, okay, there may be situations where it's not practical or feasible or for whatever reason. And I don't know, I don't want to kind of envisage all these situations. I have this law before me. It does not clearly stipulate that if you don't strictly abide by each and every letter of it, there are adverse consequences either for the judge, or it constitutes misconduct or something like that. So nobody has touched upon this point at all, and everybody is assuming that it is extremely mandatory with grave consequences if not abided by. Now, if we take a sort of a middle ground and say, yes, it is not mandatory to that extent, but it is a law, and you would, I mean, like so many laws say, take the Anti-Terrorism Act. Has it ever been abided by? Trials completed within 90 days. NAB, I think, law says the same thing. Now, is the judge removed? Is the judge sent into jail? Is he disqualified? Trial continues. I mean, you know, that's kind of, you know, showing the beacon, the light, okay, this is what you should do, but many times it's not done. In fact, under those laws, I have not come across a single case where they have been strictly abided by in terms of time. And Parliament has always, throughout, in various statutes, fixed timelines, because they want, presumably, people's issues decided quickly, but they cannot be without prescribing the consequences. So, absence of consequences, nobody is touching upon. Do you have anything to say on that?
Lord, I would submit that ordinarily, of course, one would expect your lordships to follow the law that has been
there is a very serious consequence. Even if each and every provision of this law is, other than the appellate provision, maybe the practice and procedure part is read as directory, and the 3-member committee says, well, out it goes, we don't care, we are not going to follow it. Will they not be in breach of their oath of office?
Lord,
the oath of office says they are bound to act.
I wanted to hear something from you. I mean, it can be the bloody-mindedness of the Chief Justice or of all 3 of us.
That's, even if it's directory, it's directing judges who've taken an oath of office. Then are the judges going to say, well, this is not law, and we won't abide it, and I don't know. Out goes our oath of office.
My submission was,
very difficult and embarrassing.
My submission is only this, that obviously if a law is in the field, one would expect that the judges of this court will abide by the law. What the difference between mandatory and directory is only this, that if there was not, in some case, full compliance with the law, it would not automatically mean that in that case, the entire judgment goes or it falls apart.
Now, let's take the constitutional provision, Article 199(4)(a), which is not a statutory provision, it's a constitutional provision. Is it abided by in every case? 4A, 6 months following the day from which it is made, the order? Yes. Now, let's live in the real world. I mean, how many times the orders are still subsisting? And where the government or someone say, okay, 6 months over, I'm not going to follow this order.
If I can move on from this, sir. Sir, there's another aspect of this that my learned friend before me has already pointed out, that Article 202 is framed in the identical terms as Article 191, except that it says that the rules may be made for the High Court or for the subordinate court. Now, independence of judiciary, of course, is applicable equally to the lowest magistrate and this court. There's no difference between the two. So, if there cannot be any...
Sorry to interrupt, but I just put it to you a little while ago, because over there were specific legislative competences in relation to civil procedure and criminal procedure. That line of reasoning, if advanced, would have rendered redundant legislative competences expressly conferred. So clearly, seems to me that the position of which one is it? 201.
201.
201 is
202.
202, sorry, is perhaps different from 191.
My lord, once again, I am drawing a clear divide between independence of judiciary and legislative competence.
I'm not talking of independence. I'm talking of legislative competence.
Yes, So I'm talking of independence of judiciary because I've dealt with the legislative competence already. As far as independence of judiciary is concerned, if it is argued that allowing the statute to override the Supreme Court rules is destructive of independence of judiciary, then that will apply in full force to any statute that regulates the procedure of the high courts or the civil courts over the existing rules. Now, those rules, sir, are the West Pakistan High Court rules as applicable in the different provinces. In Sindh, there is the Chief Court, original side rules. There is the various orders of the CPC.
No,
there
Mr.
is.
Salahuddin, listen here, I'm here.
Sorry.
क्या आप कोई ऐसा प्रोसीजरल लॉ साइट कर सकते हैं जिसके नीचे रूल मेकिंग की पावर दी गई हो?
Hello?
कैन यू साइट एनी प्रोसीजरल लॉ जिसके नीचे रूल मेकिंग की पावर दी गई हो?
Civil Procedure Code.
Civil Procedure Code is a blend of substantive and procedural law both.
So as is this law?
प्योरली प्रोसीजर लॉ की बात कर रहा हूँ. कोई ऐसा दुनिया में प्रोसीजरल लॉ है जिसके नीचे रूल मेकिंग की पावर दी गई हो?
My Lord, my submission is that this law also is a blend of procedural
ये तो
and
बना हुआ है ना,
substantive, like the CPC.
आप ये
or
कह
the
रहे हैं
criminal
सब्जेक्ट
procedure
टू
code.
कॉन्स्टिट्यूशन एंड द लॉ. वो लॉ जो उसका जिक्र है वो सब्सटेंटिव लॉ है, ये प्रोसीजर लॉ है. अगर आप उसे प्रोसीजर लॉ कंस्ट्रू कर रहे हैं, अगर आप उसे प्रोसीजर लॉ कंस्ट्रू कर रहे हैं, तो क्या उसके नीचे मजीद रूल मेकिंग की पावर दी जा सकती है? क्या दुनिया में कोई ऐसा कानून है कि प्रोसीजर लॉ के नीचे रूल मेकिंग की पावर दी गई हो?
Salahuddin, Article 202 is relevant to the High Courts.
सियासत, मईशत समेत अहम कौमी मामलात पर दयानतदाराना कौमी डायलॉग की जरूरत है. दरपेश चैलेंजेस के हवाले से बहैसियत कौम हम सबको अपना किरदार अदा करना होगा. मुल्क
प्रोविजन है ना, 199 के अगेंस्ट कोई अपील है कॉन्स्टिट्यूशन में?
Apart from what is written in 185, नहीं है.
No, but
नहीं
you see,
सुनिए,
that
190
was-
प्लीज
that was saved
लेट मी
under
कंप्लीट सर
270.
प्लीज. आर्टिकल 199 की अपील है कॉन्स्टिट्यूशन में?
Directly.
नहीं है. तो लॉ रिफॉर्म्स ऑर्डिनेंस के तहत कैसे दे दी फिर?
That is my case. Even
लॉ
if you
रिफॉर्म्स
look-
ऑर्डिनेंस में the provision is that if at original stage one appeal is provided, then intra-court appeal does not lie. In case there is a direct writ against the order and there is no appeal in between them, then the intra-court appeal lies unto the divisional bench. और ये कॉन्स्टिट्यूशनल प्रोविजन है, तो आर्टिकल 199 की तो कोई अपील नहीं है, तो फिर वो भी नहीं दे सकते ना.
और जरा बात मेरे कलीग की बात अगर मैं आगे ले चलूं, वहाँ तो फिर भी अपील थी. अगर आप अभी भी हमारे जजमेंट्स हैं कि एक ऐसे केसेस में आप आ सकते हैं डायरेक्टली अंडर 185 ऑफ द कॉन्स्टिट्यूशन, वहाँ तो अपील मौजूद है, आईनी अपील है, उसके बावजूद एक इंट्रा कोर्ट अपील दे दी. तो यहाँ तो वो दरवाज़ा भी नहीं है. तो वो मे बी दिस इज ऑन अ हायर पेडिस्टल दिस केस, टेकिंग व्हाट माय लर्नेड ब्रदर हैज सेड फर्दर.
The one argument that was made by Bhandari Sahab on this was
नहीं, वो फिर जो कॉन्स्टिट्यूशन की अपील आई है वो कैसे आई है? मतलब वो फिर अगर वो भी गलत है ना, 199 की अपील फिर नहीं होनी चाहिए ना लॉ रिफॉर्म्स ऑर्डिनेंस.
if the logic is against section 5,
दिस इज द लॉजिक.
logic has to apply to the law reforms
1972 का लॉ रिफॉर्म्स ऑर्डिनेंस पे रिडंडेंट होना चाहिए ना.
and the defense, the argument that was raised by Bhandari Sahab on this was कि
72
law reforms
ordinance was
ordinance
saved in the
Sir,
constitution.
जी बिल्कुल उसी पे आ रहा हूँ सर, that the law reforms ordinance was saved by Article 269 of the Constitution. But as your lordships have held in full courts, that those provisions 268, 269, 270 are for retrospective validation. They do not prevent that law from being struck down on grounds of present conflict with the Constitution. Benazir Bhutto के केस में and Iftikhar Mohammad Chaudhary के केस में.
Law reforms ordinance is a continuation of the letter patent law. That was a totally different letter patent के against जो है वो इंट्रा कोर्ट अपील उस लॉ में लाया करती थी और उसी को उन्होंने incorporate इसमें किया and then subsequently it was saved under Article 270.
Yeah, your lordship is absolutely.
That's a totally different.
But your lordship will appreciate the letters patent appeal was modified by the law reforms ordinance. There were provisos put in the law reforms ordinance that did not exist. So the law reforms ordinance did modify the rules.
Salahuddin साहब, जो लेटेस्ट पेटेंट इशू होते थे ना, 1861 के आप निकालने बॉम्बे हाई कोर्ट, मद्रास हाई कोर्ट, कलकत्ता हाई कोर्ट के वगैरह वगैरह, मुझे लाहौर हाई कोर्ट का नहीं पता, but at least in some of them, maybe also in the letters patent of Lahore High Court, there was a clause, a specific clause in the letters patent, that these letters, provisions of these letters patent may be amended by the Indian legislature. There was a specific grant of power going back to 1861. So, letters patent appeal, which is an appellate provision, and under letters patent की position बिल्कुल फर्क थी. दूसरी बात, ये jurisdiction होती है ना, appellate power is a substantive power. आप जरा kindly देखिए जो concurrent list में जो power था equivalent, जो entry थी equivalent to 55, jurisdiction of all courts except the Supreme Court. So that included the jurisdiction of high courts. In terms of legislative competence, I'm not speaking otherwise. In terms of legislative competence, an appellate power is regarded as residing in the relevant procedure, the entry relating to procedure. So, in a civil case, and we know that Article 199 is regulated by CPC, old case law.
Yes, madam.
So, in the case of CPC, 199, the right of an appeal could be given for two reasons. One, because as my learned colleague has pointed out, it descended from letters patent appeals, and letters patent was subject to amendment by the legislature. Secondly, because jurisdiction of all courts could be regulated by law, concurrent law, federal law, provincial law, and for purposes of competence, the civil procedure provision included rights of appeal. Ditto, likewise, the power relating to criminal procedure. So that's a totally different situation, you see. Here, where the Constitution is expressly reverting to the structure of the Government of India Act 1935, where very carefully, the federal court was shielded from the legislator. It's a different thing.
Mr. Salahuddin, this was my question right from the beginning. ये जो Ordinance 72 के तहत, देखिए Ordinance 72 में 199 आर्टिकल कॉन्स्टिट्यूशन का है, उसमें अपील की पावर दी अगेंस्ट द ऑर्डर ऑफ द हाई कोर्ट, whereas Article 199(5) restricts the High Court from calling into question any order of the High Court. उसकी मौजूदगी में लॉ रिफॉर्म ऑर्डिनेंस को 270 में प्रोटेक्शन दी गई. क्या कॉन्स्टिट्यूशन मेकर ने ये नहीं समझा कि ये ठीक लॉ है, बावजूद इसके कि कतगन है, आप इसको अपील की रेमेडी दे दो. इसके बावजूद इसके कि 199 में एक रेमेडी सुप्रीम कोर्ट में भी उसको अवेलेबल है. तो इस तरह दो अपील की रेमेडीज मिल गई. तो उस एनालॉजी पे अगर हम जाएं कि कॉन्स्टिट्यूशन मेकर्स तो इससे एग्री कर रही हैं, कोई बात है, बाय इवन बाय ऑर्डिनेंस यू कैन प्रोवाइड
an appellate right.
Why not through
I'm in respectful agreement with your lordship. Now, the other thing that I wanted to point out is that the Civil Procedure Code, all the different provincial assemblies have amended it, made wholesale amendments to it in the last 5 years, since there's been a bit of a laggard. But the rest of the provinces and the parliament in case of Islamabad, they made huge changes to the CPC. And those changes have been given effect over the previous civil court rules that were framed by the respective high courts. So to say that any legislative interference in the rule-making power of the courts, of the high courts, or the Supreme Court, to say that that is not permissible, then all those amendments in the CPC will also need to be struck.
All those amendments have been made in the substantive part of the CPC.
There is legislative competence to do that for other courts, but not for the Supreme Court. There is a clear distinction.
Lord, but 191 and 202 are in identical terms. The principle applicable here would apply then with equal force.
One question, this is like one Karachi lawyer to another Karachi lawyer. Because you mentioned the Sindh Chief Court rules original side. उसमें एक रूल है कि to the extent that the first schedule of the CPC clashes with the Sindh Chief Court rules, original side, the original side rules will take precedence, will supersede. So on your theory, would this, whatever rule it is, would this be ultra vires?
Lord, that as far as that
I'm
was,
asking you, on your theory, it would seem that it is ultra vires.
well, Lord, that as far as I can understand is because of general and special law. The procedure for the CPC is the general, and for the High Court in particular, it's
बात तो
special.
competence की है ना, बात तो फिर competence की है. आप कहते हैं कि जी वो it's the reverse. The competence is the reverse. Law can override the rules, but not vice versa. मैं आपको एक मिसाल दे रहा हूँ. कब आए थे हमारे ये original side 1944 के है ना?
1930
rules में original side.
I've forgotten the exact
lawyers,
years.
Zuhairi Saab.
I think Abid Saab might remember.
Anyway, that's on the lighter side.
आप कितना और टाइम ले रहे हैं आप?
Sir, I'm just trying to wrap up.
जी बताएं.
जी sir.
क्योंकि there is a mutiny against the master. Murmurings of a mutiny against the master.
My lord, my colleagues who are waiting have also
here
assured me of great retribution if I don't wrap up quickly.
You know, but there may be a pen down strike. You cited the example of Nepal. So a similar strike has been threatened, that you are the last counsel for the day, and the rest we'll hear tomorrow, inshallah, at 11:30. So please wrap it up now.
I'm wrapping up, sir. Sir, एक और चीज मैं जरा दिखाना चाह रहा था. If your lordship sees, जहाँ law का लफ्ज है, because an expansive interpretation of law was urged. If your lordship will see, जो 175(1) की power है, such other courts as may be established, and that is why we have to look at the context of each of the provisions, such as other courts as may be established by law. Obviously, over there, the law could not be judicial precedents of this court. While law is normally has a, now similarly, 175(2) में, फिर उसी तरह सर 192 में, जो power है to that the High Court shall have as many judges as may be prescribed by law. Again, it could not be law that is prescribed by any judgment. So the argument that 191 has to be treated as this grand provision that includes everything and rules and bylaws and all that, I would humbly submit that that is not borne out.
The law is made under Article 175(2). The pursuant to Article 175(2), this law has been made. जो उसमें लिखा हुआ है, read with Article 191.
बिल्कुल. अब सर, now
ये जो इसमें आप 2 को पढ़ेंगे ना, इसको 187 के साथ पढ़िए. 187 में इसका रेफरेंस है.
जी सर.
187 पढ़िए.
Subject to clause 2 of Article 175, it recognizes
ये
that.
jurisdiction confer जो हो रहा है ना 175(2) का, it is read with Article 187 as well. उसी का रेफरेंस है वहाँ.
बिल्कुल.
कि जो भी सुप्रीम कोर्ट पावर एक्सरसाइज करेगा, that is subject to Article 175 sub Article 2.
बिल्कुल. I agree, sir. सर, एक और जहाँ तक इंट्रा कोर्ट अपील की वो जो सेक्शन 5 वाली इशू है, I just wanted to briefly point out the occasions where Parliament has created an additional appellate jurisdiction on this court over and above what is written in 185, Section 9, 155 and 202 of the Election Act, Section 44 of the Competition Act, Section 48 of the Legal Practitioners and
What
Bar
are you
Council.
referring to, sorry?
The power of Parliament to confer an additional appellate jurisdiction on this court, which is not anywhere mentioned in 185. 185 talks of only orders of the High Court, but they have created appeals coming from different forums, and those, the constitutionality of that has never been...
Including contempt of court.
Yes, sir. And finally, Section 19 of the contempt of court.
Contempt of court was the ordinance. It was saved by 270, and it was saved in the 18th Amendment.
Yes, sir.
So that's a different
But
category.
again, what I would urge is that the savings is retrospective validation. As this court has held that the Article 268 up till 270, AAA, etc., They don't mean that a law that is saved can continue despite being in violation of some constitutional provision. So the Contempt of Court Act might have been saved because it was
Salahuddin,
promulgated.
which was the third law, election, competition, which was the third one?
Sir, Section 48 of the Legal Practitioners and Bar Councils Act.
So in Section 54 of the Land Acquisition Act also.
Ji, bilkul, that is an example. And that is an example of a provincial law creating.
आपने कहीं लिखा, आपने सारी चीजें लिखी हैं कहीं?
जी सर.
अगर नहीं लिखी हैं, ग्लेस दे दीजिएगा, ठीक
जी
है?
बिल्कुल सर. They are in my concise statement.
If I could just ask a question, is there no difference between creating a right of appeal to the Supreme Court from some subordinate court's order or forum's order, as opposed to creating a right of appeal at the Supreme Court from an order of the Supreme Court itself? As I see it, there is a difference. So the examples that you give are a little different. This is bringing a right of appeal to the Supreme Court, whereas we are looking at the right of appeal against an order of the Supreme Court in a jurisdiction given and spelt out by the Constitution. So the question here is that if the Constitution has provided for a right of appeal or has not provided for the right of appeal, can, by way of statute, that right be created in the Constitution? I mean, there is a difference. Looking at laws which provide a right to the Supreme Court is something a little different than what this case is about over here. And these examples, at least I don't understand how these examples would help your case over here.
The law that specifically creates an intra-court appeal is the Contempt of Court Ordinance.
Yes,
Section 90. It creates an intra-court appeal from this court to a larger bench of this court. So that is a precise.
That is a precise, but there is an explanation and a judgment that deals with that specifically, which again doesn't answer the question that we have asked you again on competence, and I'm asking you how an amendment to the Constitution can be made, or a provision which is not given in the Constitution can be made through ordinary law.
Your leadership will appreciate that Article 204 of the Constitution does not create any right of appeal. It only allows Parliament to regulate the punishment of contempt.
And
in
this
that
word,
regulatory power and appeal under Section 19.
This word regulate has been explained that it means conferring of some form of rule-making legislative power. There are judgments to that effect. So the word regulate has been used. So election key provision may, the word regulated by law is used, as Mr. Bhandari had pointed out.
So
again, it is a little different.
My humble submission.
Salahuddin, ye bataiye, give an example. How can the jurisdiction under Article 184(3) uski expansion kaise? You see, this is a precise question. Secondly, there are various jurisdictions of the Supreme Court. It is not that they all separately would be expanded. That is why, you see, जो settled principles हैं, whether वो हमारी judgments हैं, that these entries have to be interpreted liberally and broadly. But सिर्फ इतना बता दीजिएगा, give one example how through law can Article 184(3) jurisdiction उसकी expansion कैसे होगी वो बता दीजिए.
Sir, मेरी submission, and this will be my last submission on this issue of appeal, is that even if a presumption of finality is attached to the 185 appellate jurisdiction, and I think that is quite reasonable, it cannot just keep in endless loops of appeals over there. A presumption of finality exists for appellate jurisdiction. That presumption is not there for the exercise of original jurisdiction by this court. And the reason for that is, sir.
I didn't understand.
Sir, even if it is said that 185 की जो appellate jurisdiction है, there is a presumption of finality attaching to it, because of which Parliament cannot create an additional statutory appeal over and above an appellate case already decided by this court. that presumption can certainly not be applied to the exercise of original jurisdiction under 184.3.
Okay.
And the reasoning, one submission that I'll make on that point is, sir, and it carries on from what Mr. Zaid Ibrahim had said. Article 2A and वो जो दो judgment cite की थी, Federation of Pakistan versus Public at Large, etc. The right of appeal is part of the injunctions of Islam. Now, if you have two possible constitutional interpretations, one allows the parliament to create a right of appeal. One says that no, parliament cannot create a right of appeal. The interpretation that is in consonance with the principles of Islam is to be preferred.
Is it enlargement of the existing jurisdiction?
My lord, enlargement ke hawale se, I have a very plain and simple understanding. Enlargement means to make larger. It can mean that the scope of an existing jurisdiction is made broader and deeper. It can mean that new things are added to that jurisdiction. It is to be treated, it is a legislative entry after all. It is to be given an expansive meaning.
Mr. Salahuddin, in right of appeal, what do you say about the retrospective effect to the right of appeal?
Jesus, that is...
And there is no end to this. There is no cut-off date.
My lord, that is...
It will start from 1973, from the date of the Constitution, or what?
My lord, I'm going to take a slightly cowardly way here. There is one interpretation that your
इसके
lordship...
साथ ये बता दीजिएगा, क्या जिन cases में review already exercise हो चुकी है, will they be also covered?
No, sir. They will not. Now, one interpretation that can be taken is it's a remedial statute, etc. It's meant to confer, and then if it's remedial and retrospective effect back to 1975. The other more limited interpretation that could be taken is, sir, that it is only meant to open the door for those cases that were decided within the 30-day limitation period mentioned in section 5. So it would apply to those cases that had been decided 30 days prior to the promulgation of the act. That is the limited retrospectivity.
This is not the interpretation of this law. This is prior to commencement of this act. This is open-ended, you see. This is one of the interpretation which you are giving. Within 1 month, jo decide hui hai, that can be taken into consideration.
To save the constitutionality of the law, your lordships are empowered to give it a limited reading or even read it down to that. Now, two more things and I'll just wrap up, sir.
You were on the last thing now. I said you were on the last thing.
Yes, sir. These are just for the specific provisions, the issues with the specific provisions that have been raised. I'll run through them, sir. एक बात की गई थी, sir, कि the gatekeeping imposed by section 3, that the committee is an administrative committee. It gatekeeps the exercise of judicial powers by this court. Now, 1 month ago, sir, I filed a petition for the Bar Council on challenging the amendments to Official Secrets Act and the Army Act. The registrar returned it on the basis that this is not of public importance and no question of fundamental rights is involved. That appeal will lie, and it's an appeal conferred by the procedural rules. It's an administrative appeal. It will lie to a single judge of this court, and he may accept it or reject it, and I'll have no remedy against that. Now, if the registrar with the single judge in chambers can act as an administrative gatekeeper over the exercise of judicial power under 184.3, I fail to understand why a committee cannot do so.
The right of appeal lies to the chamber.
Yes.
In case of registrar, if the committee rejects, then where the appeal lies?
Sir, but your lordship will appreciate
single judge.
The right of appeal to the single judge in chamber is not a
No, it is
judicial.
Article
It's
184
only an administrative.
That is
One
known to
Article
everybody.
184(3), the committee will decide whether it is a case of public importance or not. In case they reject, in case registrar rejects the appeal, then the appeal lies in chamber to a single judge of the Supreme Court. ठीक है? यहाँ पे अगर कमेटी ने रिजेक्ट कर दिया, उसके बाद फिर वो कोई रास्ता नहीं है उसके लिए. वो फिर जो कमेटी has rejected, then there is no right of appeal unless we will read it down.
Yes, yes, that is.
आप कह रहे हैं वहाँ पे एक जज है, यहाँ पे 2-3 है, तो आपका क्या कंटेंशन है कि तो?
I know, and perhaps there is perhaps one logic behind it, because Article 199 की जो jurisdiction है, that is available. The remedy is available to me as of right if I am an aggrieved person,
No, Mr.
etc.
Salahuddin-
जो 184(3) की जो
Mr.
jurisdiction है,
Mr.
that is a
Salahuddin-
discretionary.
There
Sir, एक minute.
नहीं तो यहाँ जो अपील आएगी ना, it's not an appeal deciding a list. It is only deciding the competence whether it should be heard or not. Otherwise, the list will remain alive. You can take it in a suit, you can take it in a writ jurisdiction. I don't know, whichever way you want to take it. But we don't kill the list. I mean, it's okay.
Exactly.
You don't meet the test in our opinion. That opinion, your point is that if one judge can get it wrong, the registrar gets wrong, you have it before one judge.
can still go and
Here the 3 judges get it wrong. So
And because your lordship will appreciate that when I come in 184(3),
Mr.
I can show to your lordships
Mr.
that I have.
Salahuddin-
Sir, let me just complete this and then I can show to your lordships that I have a case of great public importance.
How are you
It
reading
engages
this right in
fundamental
section
rights,
5?
But your lordships may still
How are
decide not to
you- how
entertain
are
it
you-
and send me back to the High Court.
How are you reading this right in section 5? Section 5 says, by an order of a bench exercising jurisdiction under 184(3). So how are you reading the right under section 3, that if you are denied, that case is not fixed, that appeal will come under section 5? It doesn't come under section 5.
I'm not reading that, your ladyship. I was talking about the fact that an administrative gatekeeper was present under the old system for 43
आप ये
years,
कह रहे
and
हैं
it is
कि
present.
section
Mr.
3 के
Salahuddin,
under
Mr.
there is
Salahuddin,
an administrative power
Please
being
read section
exercised.
3.
Please,
Please
sir.
read.
Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under section 2 for examination. And if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by chapter 1 of part
Please
2
stop
of the
here. There are 2 conditions precedent. One is case of public importance, and the other is the infringement of the fundamental rights. And if this is decided by the committee, and finally it is said that it is a not fit case to be entertained under Article 184(3) of the Constitution, and the person goes to High Court under Article 199, and thereafter, if appeal comes to the Supreme Court, that would be against the order of the High Court under Article 185.
yes.
It would not prejudice the case of that person, and because of the reason that already opinion has been given 3 senior judges of the Supreme Court.
Lord, my humble submission is it would not prejudice the case of the petitioner because it is merely an administrative decision. It is not just like the single judge in chamber.
On judicial
His
side-
order has no judicial precedential value.
Within the parameters of
On
184(3).
judicial
तो ये
side, there are
पार जो है ये रजिस्ट्रार जो पार एक्सरसाइज करता है that is an administrative power. The 3-member committee would also be exercising that same powers. Previously they were being exercised by the registrar, now they'd be exercised by 3 judges. But there is a judgment of this court which says no. The question whether it is a question of public importance involving fundamental rights, it is a judicial question and has to be judicially decided. How do you answer that?
Lord, my submission would be that even after that judgment, and I think it's 1997 वो PIA वाली
नहीं, recent
Yeah.
judgment.
recent भी तो है already.
एक से ज्यादा जजमेंट है
जी जी बिल्कुल बिल्कुल.
of appeal in chamber.
But
इसमें कहा गया कि the word used is adjudication. The very word used over here. This is a matter of adjudication.
Those
That
were
is a judicial power.
those were orders. The more recent ones are the orders passed by my Lord Mansoor Ali Shah in as single judge sitting in chamber,
one
which
of
is
them
an
is even-
administrative power.
one of them is even
But there are judicial findings of this court also on this, and I think that case relates to
Section
1998.
three-
But all I'm saying there is, sir, that despite that,
What is
the
the solution?
administrative gatekeeper has continued for after that judgment for 23 years.
वो छोड़ें, हम तो एक्ट को
And
देख रहे हैं।
there is
तो आप तो हमसे कह रहे हैं कि हम उसको एक्ट में कंटिन्यू करते रहे।
my lord,
थोड़ी
it
सी
has
दिक्कत
not,
नहीं हो रही
all
है।
I'm saying is it has not, that aspect has not previously troubled
Yes, but there
this
is a
court
slight
so long
difficulty
as it
here.
was done by the registrar.
सलाउद्दीन ये जो रजिस्ट्रार के ऑर्डर के खिलाफ अपील सिंगल जज को है, ये अपील की रेमेडी बाय रूल्स प्रोवाइड की गई है।
जी सर।
और इसी तरह ये जो कमेटी बनेगी सेक्शन 3 में, ये भी तो एडमिनिस्ट्रेटिव कमेटी, इसके खिलाफ भी रूल्स में
अगर रूल्स में आप एक अपील दे दें तो that
फॉर्म
would be
दे सकते हैं, देयर नो प्रॉब्लम।
बिल्कुल बिल्कुल सर, बिल्कुल। और
अजीज साहब खत्म।
I'm done, sir. As for sir, sorry, one last aspect, and that relates to the question that Her Ladyship Aisha Malik had asked. What is the effect in Section 5 when if a full court is formed or a 9-member bench is formed, etc.? I would rely upon the principle that there is a difference between a statutory provision that is ex facie discriminatory and a provision that may only be applied in future in a discriminatory fashion. The distinction is drawn in Jabindra Kishore, that is PLD 1957, Supreme
It's not a
Court.
question of discrimination. It's a question of the right of appeal being taken away, full stop.
Yes, that issue also I'll cover. But first of all, जो discrimination वाला aspect है, because Article 25 was said that one person is being denied the right of appeal just because a committee has formed a larger bench. So the other judgment is Shaukat Ali Mia,
It's not just a question of discrimination.
का citation क्या है?
PLD 1957, Supreme Court 9, and PLD 1999, Supreme Court 1026. That's Shaukat Ali Mia.
It's not just a question.
Repeat this. It's 95 Supreme Court,
So 99 Supreme Court 1026.
1026 और
शौकत अली मियाँ का केस सर, वो जो फॉरेन एक्सचेंज
जी पहली कौन सा
पहली जबिंद्रा किशोर का था सर, PLD 1957, सुप्रीम कोर्ट पेज 9.
Okay.
My question was not only of discrimination, but my question was that it is a substantive right that the law provides. And if the law is to be upheld, then on what basis can the committee deny any person that substantive right? So it's not just a question that some will be allowed and some will not be allowed. The question is then that actually you cannot make a full court or a larger bench because that right of appeal will be denied to a person. And there is no basis to deny a substantive right.
The solution that I will offer, and then I will rest.
Solution तो बाद में आएगा ना, पहले तो जवाब होना चाहिए कि ये हो भी सकता है कि नहीं, फिर solution आएगा.
The answer that I will offer.
You see, the thing is, in practical terms, the 3-member committee, essentially that committee would decide in which cases an appeal would be available and in which it won't be. Because by constituting a bench more than 8 judges, it would deny the right of appeal. And by constituting a bench of less than 8 judges, it would provide a right of appeal. And what is the criteria here?
एक second. There are two concerns. One is the past, one is the present. If this law is sustained, then naturally the committee will realize the provision of an appeal and will make an attempt not to do 9 benches plus, okay, realizing that, unless it's a matter of, I don't know, I don't want to state it because it may come to haunt me, but having realized that, so as far as the past is concerned, that's a different matter altogether. So committee being cognizant of this law will try that in 184.3, we do not go and constitute 9 plus benches or if you don't have enough judges to hear an appeal. That's a simple answer. If the committee wants to close its eyes to it, that's another thing. Then you will say that the fault does not lie in the law, the fault lies in the committee and
in
your
discriminatory application of that law.
Yes.
Now that is why I was citing
by
these
that
judgments,
token,
because these judgments say
for all intents and purposes, a full court and 184(3) can never be made.
Sir,
अब इसका take this case for instance, इसकी अपील चलें, हमने कहा ये दो ही हो सकते हैं ना, असिस्टेंट करें, स्ट्राइक डाउन करें, कुछ लोग खुश नहीं होंगे, अपील कहाँ होगी? तो एक सिंपल जवाब है, नहीं होगी भाई, सबने सुन लिया क्योंकि जिसने अपील सुनना था वो भी बेंच का हिस्सा थे। अब खत्म करें बात को।
जो जजमेंट्स मैंने साइट की थी वो ये कहती हैं कि अगर कानून ex facie discriminatory नहीं है, मगर it allows for an authority to in future apply it in a discriminatory fashion, then what this court can do is
I don't like this word discrimination. Sorry, I completely don't like this word discrimination, because you are saying that actually the law, this law, very law, gives you a right to appeal, but then it may be taken away in the future, so it is discriminatory. The other argument could be, the other simpler argument would be that if there is no appeal, then it's all right.
What happens to the right of appeal then?
Salahuddin, the very fact that this law, every section, argument is being made, this can be read down, this can be read up, this can be ignored, this can be taken up when the situation actually occurs. That itself shows how defective this law is.
As far as I am concerned, there are only two issues that I have highlighted.
पहले ये appeal के context में, there are 15 judges. All of them are hearing this case. And in any case, the appeal would also lie to the same court, to the same judges. What prejudice would it cause if a full court hears it? No prejudice would be caused.
My lord, my case would be, my case is that if a full court is constituted, then every judge of this court has been heard, then any right of appeal is illusory, the loss of that.
So then we just ignore the law,
Sir,
we just ignore the substantive law for the right देने का. But you see, when you are arguing a point, you have to keep in mind that you are arguing, you are saying that because all the judges are sitting, so that right which is given under the law, that is just an illusion now because all the judges have heard the case. So what happens to that person who says, where is my right of appeal? How do you explain that to him कि ये तो एक illusion है जी, सारे judges ने सुन लिया इसलिए इसका मतलब है आपका case बंद हो गया. So then the question is कि वो right block नहीं हो रही, वो arbitrariness नहीं होती.
I'll address this question. All I'm saying is that to read section 3 and 4 and 5 harmoniously, your lordships can lay down guidelines even for the committee, that the committee will consider that the right of appeal should not be snatched away from anyone. However, where a full court is constituted,
section
that
3
issue becomes
Mr. Salahuddin,
that is my
section 3 में not less than 3 judges है, ठीक है? अगर कमेटी ने कहा कि इसको full court में जाना चाहिए, तो ये कमेटी डिसाइड कर सकती है, नहीं कर सकती?
कर सकती है.
अब आप अपील में अगर
मगर
जब आप
9
आएंगे,
से 15 के दरमियान
listen, कमेटी में constitute the full court or not? कमेटी में constitute. वो कहते हैं ये इतना important question है कि हम समझते हैं कि पूरे full court को सुनना चाहिए. अब आप अपील में जब आएंगे,
you have yourself said, this was the point I was going to ask you कि आपकी theory के मुताबिक 9 to 15 नहीं हो सकते.
नहीं, उसमें मैं harmonious interpretation
या 7 सुनेंगे maximum या full court.
और ये अपील में भी जो right है section 5 में,
because it does not discriminate with anybody in that case.
That's a pretty strong.
Mr. Salahuddin, Salahuddin साहब, अपील section 5 में जो है वो full court अगर बनता है तो अब यहाँ पे अपील करनी है constitution to a larger bench. अब जब full court ने अपील सुन ली तो larger bench तो आपके पास है ही नहीं. तो ये इसकी एक slightly जो एक understanding है, जो what I can understand.
Yes, sir, exactly.
अब पता नहीं इसकी understanding आपकी different हो सकती है.
No, that is exactly my understanding, sir.
बस let's stop it there. लिखिए इसमें. Mr. Abid Zubairi, notice was issued to the Supreme Court Bar Association, and Mr. Abid Zubairi, President of the Supreme Court Bar Association, on behalf of SBCA, states, refers to CMA 82772023, filed by SBCA, full stop. He has completed his submissions in and states in opposition to the act. इसके बाद थे CP number 33. CP number 33/2023. We've heard Mr. Adnan Khan, learned ASC, on behalf of the petitioner, and say वो रिव्यू वाला सिर्फ कहते ठीक है, बाकी गलत है ना? किधर गया अदनान? Where is Mr. Adnan? जी
वो चले गए, नजर नहीं आ रहे सर।
ये तो देखिए, अब आप ये देखें आदिज मैनर्स। अभी वो चले गए, मैं थक गया, मतलब हम बैठे हैं उनके लिए और वो चले गए। अब चलिए, has concluded submissions. CP number 18 का लिखें, filed in person. ये किसने फाइल की थी? आपने। And by a learned ASC of this court, and he has completed his submissions, which ASC नहीं है, states as an advocate of the Supreme Court, and he's been heard in his private capacity. अच्छा, this concludes submissions made by all. Made by all those opposing the act. Full stop. Mr. Next paragraph लिखते हैं. Notices were also issued to political parties, and Mr. Zahid Ibrahim Learned ASC states that he represents PMLQ and has filed CMN 3991/2023. यही आपने फाइल किया था ना? Full stop. And he has concluded his submissions. Thereafter, we heard Mr. Salahuddin Ahmad on behalf of PMLN, whose filed CMA number 8301/2023, and Learned Counsel concluded his submissions. Full stop. It is now 5:40. Adjourn to कल की तारीख डाल दें at 11:30. 11:30.
सर जमात इस्लामी पाकिस्तान की तरफ से
किस तरफ हैं?
मैं सर जमात इस्लामी पाकिस्तान की
किस तरफ हैं?
जी सर, मैं जी सर इस एक्ट के हम सपोर्ट करते हैं। मतलब गुलाम मुहिउद्दीन साहब आए।
The only party which is not represented, or significant party rather, is the Pakistan People's Party. Mr. Farooq Naik is, I'm told, that was appearing but then has stopped appearing. So then we have no point of view of the Pakistan People's Party, a major political party of the country. अच्छा, चलें, खैर, can't force anybody. नहीं, वो जमात इस्लामी तो सपोर्ट कर रहे हैं ना, लॉ को सपोर्ट कर रहे हैं। आप भी सपोर्ट कर रहे हैं ना, तो आपको कल देखेंगे जो
सबमिशन इन राइटिंग हैज बीन फाइल्ड सर।
अगर आप मजीद कुछ नहीं कहना चाहते,
कुछ नहीं कहना,
आप दोनों ने अच्छा इनका लिखें।
आपने कहना
नहीं सर,
अच्छा
भी कुछ नहीं,
जो भी इन फेवर आर्गुमेंट्स।
मिस्टर सैफुल्लाह कौंडल।
जी सर, जी सर।
मिस्टर आप एएससी हैं या नहीं?
नहीं सर, मैं मरकजी लीगल कमेटी का मेंबर हूं जमात इस्लामी
आप
पाकिस्तान।
वकील हैं क्या हैं?
मोइनुद्दीन,
I think advocate and states that he is a member of the Central Legal Committee of the Jamaat-e-Islami and that he has filed, कुछ फाइल किया आपने?
जी सर।
कुछ फाइल किया है?
नो सर।
अच्छा, and states that he supports the act.
करते हैं सर,
He supports the act. Full stop. इसमें लिखिए Mr. Kamran Murtaza, learned ASC, represents Jamaat-e-Ulama इस्लाम,
पाकिस्तान से,
हाँ,
जमीयत उलमा इस्लाम पाकिस्तान से।
अच्छा पाकिस्तान भी लिखते हैं,
पाकिस्तान से।
JUI पाकिस्तान, एंड आपने कुछ फाइल किया है?
मैंने फाइल किया।
And has filed CMA number?
So just giving, sir.
So and so, and CMA number 83192023, and states that this his submissions are contained therein in support of the act and does not want to add anything further, save क्या इनका कहते हैं, adopting the submissions made by other legal counsel who are in support of the act. ठीक है? तो अब कल adjourn to कल की वो टाइम लिख दीजिएगा, कल का वक्त देंगे 11:30 बजे। जरा जल्दी कर लें ब्रीफ, ठीक है? सुनाई नहीं दे रहा है। आपके तो लिख दिया ना,
हो गया वो। अब इजाजत वीडियो लिंक की दे दीजिए ना लाहौर से, लाहौर से अब इजाजत दे दीजिए वीडियो लिंक की लाहौर से। मैंने आर्गुमेंट तो
आप बैठ करके सुन लीजिए, मुस्तफीद होइए इतने बेहतरीन आर्गुमेंट से, मगर हम आपको सुनेंगे नहीं वीडियो लिंक से। आप बेशक वीडियो लिंक से बैठ के सुनिए।
माय लॉर्ड,
ओके ठीक है,
हमने पहले कह चुके हैं।
माय लॉर्ड,
चलें।
My lord, I am on court notice. I am on court notice. I represent the MQM. I'll begin my arguments tomorrow.
ठीक है, आप आपस में, if you all can work it out, who'll go first, who'll go second, rather than.
Sir, it's up to your lordship.
No,
Lawyers can never
we
work
have
it
no
out.
issue. Like today, Mr. Zahid Ibrahim decided to go first.
No. Because he was senior, that is why. And Salahuddin had come before in the case.
He's senior to you?
No, Zahid Ibrahim is senior, sir.
Okay, I didn't realize that. Okay, I thought you were senior. Anyways, आपस में आप तय कर लें, अगर कोई मसला हो फिर देख लेंगे हम।
Sir, your lordship may decide whoever goes first.
ठीक, okay.
पाकिस्तान बार काउंसिल भी है my lord,
11:30 बजे। After regular board, हाँ?
Very grateful, my lords.
Thank you.